Our next matter is file 221805 FY, titled People versus Ryan James Swartz. Mr. Swartz was originally represented by Mr. Timothy George. And since we were last here, received an appearance, I think on the 13th of December, from attorneys Kurt Richardson and David Moore, PLC. David Moore is here today with the defendant. I signed the order of substitution, I think, on the 19th, which was just yesterday. So the prosecutor didn't seem to know Mr. Moore was in the case. They had not had any discussion. Mr. Swartz is charged with assault with intent to commit great bodily harm and assault with a dangerous weapon and domestic violence. The complaining witness in all of those matters is Jenni Akers, the defendant's girlfriend, I guess we'll call her. Count 1 alleges suffocation and strangulation, which is a felony punishable by up to 10 years of imprisonment and a $5,000 fine. Count 2 alleges assault with a dangerous weapon, which is a firearm, an assault rifle, but without intending to commit the crime of murder. As I mentioned before, the prosecution did not add a felony firearm count, probably will before we're done here. Count 3 is domestic assault, a simple 93-day misdemeanor upon Jenni Akers. We were here previously to get in the file, and we are unable to produce Jenni Akers, and I was quite concerned, as was Ms. Davis. And the trooper involved in this matter, Andrew Lebrecht, is here. He was working on this. They were trying to find the complaining witness. They were attempting to serve her. There was an allegation she had been served, but I don't think she actually was. Mr. Marvin indicated he had spoken to her on the telephone, and she did not come. In an attempt to find her and serve her, Trooper Lebrecht went to her house with some other troopers, where they learned that the children were getting off the bus. They executed a search warrant. They did not find Jenni Akers, and I didn't know what happened to the children. However, they did find a pink firearm in the defendant's room. The defendant told me in open court that he had not seen his children in weeks. They were at her mother's house in Mount Orab, Ohio. Her mother said, well, they're not here, and I don't know where she is. They had attempted to ping her phone and otherwise locate her and weren't able to do so. So I canceled Mr. Swartz's bond under the allegation that he falsely told me he hadn't seen his children in several weeks or months, and there was a gun in his house in violation of the bond. I was quite concerned that we didn't know where Jenni Akers was, and I still don't. So the matter is set for a preliminary examination today on these charges, as well as a hearing regarding the defendant's bond. Ms. Davis, what's the status here?
Well, Your Honor, the day that Your Honor canceled the bond, almost immediately thereafter, a jail phone call was placed by Mr. Swartz to Jenni Akers. She did answer. We have the recorded phone call. From that, it appears that there have been multiple repeated over the course of this case bond violations of the two having contact and acting in concert to avoid the prosecution, and that Mr. Swartz has been actively involved in that. specifically that she asked if she should still stay in hiding or if she should come talk to the prosecutor. And he indicated that, she could stay in hiding and that there was going to be a warrant, but then there wasn't a warrant because the prosecution lied. He also.
Well, first of all, let's stop. Jenni Akers is safe and fine.
Yes, she came into our office on Monday, the 12th, which would have been the first business day after the cancellation of the bond. She was not aware that we had listened to the jail phone calls. She continues to be uncooperative as far as the case goes. However, I indicated to her I intended to go forward on behalf of the state of Michigan. And she was personally served by our staff member, Diana Wilkins, with her subpoena on the 12th and was told she needed to be here as indicated on the subpoena. She called our office today while we were in the course of the other preliminary examinations shortly after 1 p.m. and indicated to our victim advocate that she did not want to come. She was upset with the way that she had been treated when she was here on the 12th, and she didn't care if she got a warrant. She would deal with it and turn herself in. With that, we would ask that this matter be adjourned and that a warrant for contempt be issued by the court so that we can get this case on track. And we'd ask just for 1 week adjournment to do so. I know that's an unusual course to take.
All right, we have the representation that she was personally served. We also have the issue that I canceled this bond. It was also set for a probation violation hearing, or bond violation hearing, for the allegation that he was in possession of a firearm and that he was in possession of the children. I mentioned to you, Mr. Schwartz, that we had another recent case where we had some extensive Snapchat communication between a defendant who was charged with the same offense you are, assault strangulation, who was Snapchatting his child's mother, inducing her not to testify and change her story with the police, never indicating that he didn't strangle her, but he loved her, she had an overdose from anxiety and the medication, and she died. And he's being prosecuted for several things. I would think there would also be a charge of some sort of obstruction of justice or witness intimidation. Has anything been done in that regard?
Yes, Your Honor. The trooper has been following up. We still need to pull some of the other jail phone calls that have happened since this occurred, but just with the one phone call from the day of the bond cancellation hearing, there's actually 2 phone calls. One was a very short one, they got cut off. The second was about 10 minutes long, but I want to say the first 3 minutes or so are just, the recordings at the beginning, but the content of that is certainly sufficient to go on prosecution for witness tampering. That being said, the offer was that if Mr. Schwartz waived his preliminary examination, we would not add on or pursue that obstruction of justice witness tampering case. And I guess that was rejected based on where we're at here today.
Not to mention the felony firearm charge.
Correct. If he waived it, would not add the felony firearm.
Which would have been enough to induce me to waive right then. Somebody forgot to add a felony firearm charge, just it wasn't you, to someone who assaulted somebody with a gun. That's a mandatory minimum 2-year prison sentence preceding and consecutive to any other charge.
Judge, I know this isn't trial, but it's my understanding they didn't find any weapons, and it's my understanding that she's told the prosecutor that she lied.
All right,
so I wonder if is there any Brady information that's coming?
It's already been disclosed, but since you just got in the case yesterday, maybe you haven't received everything.
So there is Brady information
I'm not,
as far as recantation.
everything was provided to the court-appointed attorney that you signed a substitution with. Theoretically, they should have given you everything and you would have reviewed it before taking.
Is there more that's comes? There is, obviously, everything that's happened since the day we were here. You have new interviews with a complaining witness.
There haven't been any interviews. She stopped in to the office, but it's not an interview. I'm telling you, look, we've got jail phone calls. There's a supplemental report that just came in, I believe yesterday.
Did she tell your office that it didn't happen? That she
No,
lied?
she's never said it didn't happen.
Did she tell you that she lied?
Well, we're in a difficult spot. It puts the prosecutor in a position where they're a witness in their own case. And I don't know, you didn't speak to her yourself, did you?
I was in there with her and prosecuting attorney Marvin when she came in.
All right, well, so the prosecutor spoke to her, but necessarily the prosecutor has to interview witnesses in preparation for a hearing. That doesn't mean you can call the prosecutor and say, what did that person tell you? But I do know that he had a gun in violation of my bond order. He says it was pink, it was his daughter's gun. He wasn't supposed to have any gun. Secondly, he lied to me about not seeing his children. And today I learned that he called her from the jail on a recorded phone about a half an hour after I canceled his bond. What's your position, Mr. Moore?
I believe my client's employed. He loves his children. He wants to have a family unit. He has protested his innocence. I would ask that he would be released so that he could work, that he can provide for his family. Obviously, he needs to have abide by the conditions of not possessing any firearms, and to have no contact with the alleged victim in this matter. I know that he does want to see his kids, and in some of the, I heard one recording, Judge, he was showing love to his young child, and he was instructing his other child to behave properly. So I know that he loves his children. Again, he wants to have a family unit. He obviously needs to get through this, and he's protested his innocence. So I would ask that he could get out with a reasonable bond and be able to work and be able to see his children.
Your Honor, the best evidence of that phone call is the phone call itself, and I'm prepared to play it for the court if that's,
Well,
there's a lot more to it than just.
I took testimony on the 6th. Trooper Limbrick was here, and I put him under oath. And he testified about executing the search warrant, finding the gun, and the children getting off the bus at that location. That's sufficient for me to find the defendant is in violation of his bond. So, bond is denied. At this point, the prosecution has personally served Jenni Akers, which, as much as Mr. Marvin had engaged in discussion with her in preparation for the case, he conceded she never actually been personally served with a subpoena. She has now. She's in contempt of court, and I'm going to issue a warrant for her arrest for contempt. For failure to appear. In my career, Mr. Swartz, I've probably handled, I don't know, 10,000 domestic violence cases. I would say in more than half, the complainant is uncooperative or unwilling to proceed, including strangulation cases and serious assaults. But you and Jenny are working your own plan other than mine. They may have trouble proving this one. They're gonna have much trouble proving obstruction of justice if the tape reflects what she says it says. So that's a different thing than contempt. So we keep adjourning this thing, and it's been adjourned about 3 times. Now you're in jail with no bond. And I'm very disappointed that you called her within a half an hour when you left me. And now she's gonna come pursuant to an arrest warrant if we have to. I don't even know if she's in the state. My guess is she probably went back to Ohio. I don't know where the children are. I didn't know, that was an unanswered question we had last week. The children got off the bus at this Cranberry Lake Road address. Where are they now?
Your Honor, the children were, the day that Mr. Swartz was arrested on the bond violation, his stepfather picked up the children. I heard both of the children on the jail call as well. So to my knowledge, they're both alive and well. They were supposed to apparently go back to the Cranberry Lake Road house that night, and mom was supposed to be there. But things got crossed. The 12-year-old girl ended up running away that night because she apparently didn't feel safe with her grandfather. She also had $2,000 cash in her pocket from the defendant from when he got arrested. So it's kind of a giant mess. CPS was contacted. It's a bad situation all around, and I'm hoping that we can get some resolution here.
All right, there's several good reasons to adjourn the matter for 1 week. One, Mr. Moore and Mr. Richardson just got retained, and he's here ready to go, to his credit, but there's stuff that happened that he hasn't had access to yet, including these phone calls and whatever reports were made. Secondly, the complaining witness is not here after being personally served. Prosecutor can't do any more than personally serve her. They can't put her in custody and hold on to her until she testifies. I can do that. The question becomes, what if you don't get her here by next Tuesday? You're gonna have to proceed with what you have and leave the warrant out. By that time, you may have filed additional charges that can go in a different direction. I am aware Mr. Swartz had some sort of employment. I don't remember what it was, but this is a public safety issue and a respect for the court issue. So the bond remained canceled. I find he's in violation. The matter is set for prelim next Tuesday. As if we don't have a million other things going on that day, but that would be December 21st.
27th.
Oh yeah, December 28th.
So, are we doing it on Wednesdays?
Oh, wait, I'm looking at the wrong calendar year.
I didn't know if we were moving them back a day because
No,
it
I
was closed Monday.
December, today is the 20th, it's the 27th.
Okay.
I'm here that day, Judge, that's normally Judge Patterson's day. We've already got about 1 million things set in there, but this will take priority. Mr. Moore, are you available on that day?
If I can do it by Zoom. I'll be in Arizona.
Is Mr. Richardson available?
It's in Florida. I'd be more than happy to do it by Zoom, Judge, if I can.
All right, under the circumstances, I will allow it. As a rule, you need to be present, but it's Christmas, you've got a vacation scheduled. This is all happening on short notice, and the defendant is in custody. so you may appear by Zoom.
What time is that, Judge?
1 PM. Let's see how much I already have on that day. It's not bad because I have too much on every day. So let's see how much worse this day is than the other day. Maybe I should have taken that time off. Are you here, Deborah?
Yes,
I
of
think
course.
I asked you that before. Oh, boy. That's not too bad. We only have 8 other prelims, including a criminal sexual conduct first degree and some other sorted stuff. Jenni Akers just called and she doesn't like what's being said. Then Jenni, you need to get yourself in here because there's about to be a warrant for your arrest for failing to appear pursuant to a duly served subpoena. This matter is continued until next Tuesday, December 27th at 1 PM. We'll be in recess.
Thank you, Your Honor.